So I woke up this morning to a rather extraordinary piece in the Times.
Many of the criticism contained within it are completely unfounded.
There are various aspects of it that I found actually borderline grotesque.
And I have to say, this feels like an editorial hit job. It feels like an absolutely direct decision that this is the line that's going to be taken, frankly, to some extent, irrespective of what was found out.
Hello, I'm Barrister Daniel Barnett, and I read in this morning's Times newspaper, 1st of February 2021, that there is tribunal system chaos. And the article was so surprising because it described a tribunal system that I simply didn't recognise, that I wanted to talk about it a little bit, show you what it said, show you why it's misconceived, and speak to some fellow lawyers, some specialists in employment law about how the Times has managed to get its take on the tribunal system wrong. The basic premise of the article is that the tribunal system has an enormous backlog, which is true, and that backlog is made up of unmeritorious discrimination claims that cost employers an absolute fortune to defend, and in order to meet that backlog, the Ministry of Justice has been forced to appoint inexperienced judges who aren't up to the task of rooting out unmeritorious discrimination claims. The article goes on to say an investigation by the Times shows the tribunal system is in chaos, with a record backlog of 40,000 cases.
Of course there's a backlog. The backlog results largely from the massive fall in cases after fees were brought in.
And claims declined quite quickly. Tribunal centres were closing left, right and centre, people being let go. There was just no forethought about what might happen in the future.
We then had the reversal in the Supreme Court of the decision on fees, and not surprisingly, able once again to exercise their rights without the payment of a fee, there was a rise in cases, and that was swiftly followed, unfortunately, by the incidence of the pandemic, which has impacted, and that's a double whammy for the system.
I don't think it's fair to say that the tribunal system is in chaos. I think all of the courts have found it, nationwide, have found it difficult to deal with the pandemic, but I think the employment tribunals have done as well, if not better, than others. And I think that the difficulty that the tribunals face is probably mostly to do with the fact they haven't had enough judges now, which is what the recent intake of judges has been aimed at addressing.
So I think where we're faced with, to use that very popular word, unprecedented backlogs and unprecedented problems, we've got to look at, and judges have to look at ways through the problem.
The article starts, inexperienced judges who have never heard a case have been hired to clear an avalanche of employment claims from sacked and aggrieved workers.
Inexperienced is an idiotic term to use when we're talking about employment lawyers with 2 or 3 decades of experience. And every judge has to start somewhere.
What the Judicial Appointments Commission have done, however, is appointed some of the brightest and best who have graced the tribunal benches, a lot more former barristers and very well-recognised solicitors are now on the bench. The change is that there is no longer a need for extensive periods of sitting practice, but there is no decline in the quality, in my experience, of the applicants and ultimate appointments.
It's an absolute nonsense to suggest that the people who are sitting as employment judges are inexperienced. These are people who are at the top of their game. These are people who have worked in employment law for, some of them decades.
If they've got the aptitude and skills and the capabilities to conduct a fair hearing, they're more than capable. And there are other examples in the system, even at a more elevated level, where people have been successfully appointed to sit in the judiciary, having no background of sitting as a part-time judge. So it's an unfair criticism of the system.
The calibre of some of the recent appointees is very high indeed, and the quality of judgment is exceeding as a consequence.
I saw the list of new appointees before Christmas, and the people who are on there are people who are very eminent in their field. They may not have sat as judges, but they've sat in the tribunal. They've brought hundreds of cases before the tribunal, and they know the law inside out. There couldn't be anybody better placed to hear the claims than these people. To suggest that they're inexperienced is frankly insulting.
Next, the article says employment judges appear to have been making a power grab, telling law chiefs that they should hear all equality cases, not just workplace disputes.
Well, as a specialist discrimination solicitor, I think it's a really good idea for a single equality court. In practice, I take claims both to the Employment Tribunal and to the County Court, and my experience of the County Court is that quite often the County Court will have not heard a previous Equality Act case because they're so rare. In practice, the Employment Tribunal judges listen to such cases week in, week out, and therefore their expertise in the Equality Act is much, much higher than the County Court. So I would be fully in favour of that.
And there is a legitimate debate to be had as to whether the cohort of employment judges may be better placed to hear discrimination disputes, given that much of the law surrounding discrimination arises in the employment sphere, than county court judges, for example. The idea that this is a powered grab propelled by ego rather than principle, which is what that seems to suggest, is completely misguided.
I mean, it's virtually the same law that applies across all these areas. Why not let these people who have that expertise deal with those claims, as opposed to putting them in front of a judge who may have no employment discrimination experience in another kind of court? It seems to me absolutely to make sense.
But again, to suggest there is some sort of Machiavellian power grab is, I think, completely unsubstantiated.
Next, the article goes on to say even employers who win their cases must expect to lose out financially every time they receive a claim for discrimination because the system is stacked against them. Just pausing there a second. Whenever I represent an employer, they always tell me the system's stacked against them. But whenever I represent an employee, they always think the system's stacked in favour of the employer. It kind of shows there is some real balance there. If everybody, from their own feelings of insecurity and persecution, believe that the system favours the other side. It really doesn't. The judges are trained and experienced in being as neutral fact finders as possible and then applying the law to the facts that they've found. Judges rarely reject equality cases without a full hearing, and there's usually no way to recover costs from the losing side.
It is possible to get costs to the Employment Tribunal, but it's absolutely right that the threshold for a costs order is a high one, and that works in both directions. So even the unscrupulous employer who loses an unfair dismissal case in extreme circumstances may be unlikely to face a costs application in relation to the employee. So it's actually an even playing field in that respect.
I don't think it's right to say the system is stacked against them. I think it is, of course, true that the case law indicates that it's difficult to get a discrimination claim struck out at a preliminary stage, but the reason for that is because it's very difficult to establish that a claim has no reasonable prospects without examining the evidence in detail, and it's not fair to claimants to strike out a case before the evidence is tested.
I just don't accept that the system is stacked against employers. I think the opposite, actually. I think a tribunal will be very reluctant to find discrimination in a case. They will look at all the reasons why certain treatment may have occurred, and it's actually a very high hurdle to find that discrimination is the reason for the treatment. So I just don't accept that at all.
If you make employment tribunals out of the reach of ordinary people, then essentially that's license for bad employers to proliferate.
And the final piece of the article I want to talk about is judges may also allow irrelevant evidence to be heard, dragging out cases.
It's certainly rare for a discrimination case to get booted out, to get struck out without getting any kind of a hearing. But there's a reason for that. Discrimination cases are complex. They largely rely on inference and difficult evidential points. And if you kick them out without a hearing, the chances of injustice are really high.
Well, if what is being suggested is that the dragging out unnecessary cases is a phenomenon unique to the Employment Tribunal, that simply isn't the case. Unfortunately, all judicial systems are prone to abuse, are prone to indulgence, often well-intentioned. But again, to think that employment tribunals do not have the powers to streamline cases is simply not the case. Cases are generally much shorter than they used to be. Lots of things which used to be part of the course, such as the reading out of witness statements, no longer occur. everything is designed to expedite the process, to keep the costs down for the parties involved and also for the taxpayer.
This part of the article referring to irrelevant evidence actually made me chuckle, because if you've ever been before an employment judge and tried to put forward irrelevant evidence, they'll slap you down pretty hard. So, again, it's just nonsense. It just shows such a basic misunderstanding of how things work.
So I think the report on the Times was a little bit disappointing and a little bit misleading. I'm not quite sure why it's gone out in the form that it has. Nevertheless, it's important to set the record straight. The employment tribunal system, whilst chronically underfunded and whilst suffering from a real problem at the moment of a backlog in cases, is not staffed by inexperienced judges, doesn't have cases extended in length because the judges don't know how to handle them, and is actually a working, effective place to get employment disputes resolved. Thank you for watching. I'm Barrister Daniel Barnett. Bye-bye.